Good afternoon, ladies and gentlemen. Welcome to Ayana Mid Plaza for a hybrid workshop event about the German Supply Chain Act, the implication on businesses in Indonesia. My name is Ardelia Priyanka and I will be your MC for today. To all online participants, welcome. We are going to start the workshop soon. Kindly set your background with the virtual background that have been sent to your email and turn on your camera for photo session. There will be a Q&A later, and for those who want to ask, can use chat box or raise your hand, and we will turn on your microphone. The material of workshop will be sent to your email afterwards. Without further ado, I would like to open today's session by inviting EKONID Managing Director, Mr. Jan Ronfeldt, to come up front and give opening remarks. Mr. Ronfeldt, the times and place are yours.
Yes, thank you very much, Adelia. Good afternoon, ladies and gentlemen, here in the Ayana Ballroom. Good afternoon. Also, I'm just looking at cameras over there. Good afternoon to all the participants who are joining us online. A warm welcome from my side to today's seminar. I'm happy, first of all, I'm happy that we can do it in a hybrid format so that we actually have the chance to see each other here and not just as a screen on the computer. So I appreciate that. I hope you too. And seeing the turnout is of course related to the topic, but also in terms of being physically present in events. I think we all, after 2 years working from home mainly, are looking forward to have that. So I'm happy that we have that. And yeah, I'm very happy that we have 2 experts today talking about the Supply Chain Act. I'm not a lawyer, so I'm not trying to explain it to you. I only know that for companies, of course, it becomes relevant, not only because it's, when Germany is your market, but as you know, Germany is a little bit the main economy within the European Union. And of course, the European Commission is also working on a similar legislation, so it will soon also become law in Europe. We will have 2 experts, Mr. Phillip Kersting from Luther, and the former head of our legal department, Ms. Cassandra, who will explain. I think they split in two parts. One is a presentation by Mr. Kersting, and then later a question and answer session where you, of course, either being online or being here, can ask questions. What does it mean for you, your business or your industry, which they hopefully can answer and prepare you. I think we are still early in this process. The law, it becomes in effect next year, so we still have time, but we thought we'd do it early so that actually you as companies have time to prepare for it. And that is the whole purpose of today's event, that you are in time being able to understand what would be the impact or most likely be the impact for your company or your industry, and that you have time to prepare. Also, having the chance to get some of your customers back you might have lost in the last couple of years with other company suppliers, competitors from, I don't want to, let's say Bangladesh or the other countries I just mentioned. So that by being prepared, being able to fulfill this requirement, you're actually, your business, your setup is up to date. And yeah, I hope, to make it short, I hope you have a lot of questions. Use the chance. You have free advice from a lawyer. That doesn't often happen, so you can use this chance and ask him. And even if he cannot answer everything right away, I'm pretty sure he will be able to do some research and help you later. Thank you very much, and I hope you enjoy the event. Thank you.
Thank you very much, Mr. Ronfeldt. Before we start the session, we have a token of appreciation for Mr. Phillip Kersting. I would ask Mr. Ronfeldt to kindly get the honor to give it to Mr. Kersting, and kepada rekan-rekan media silakan mengambil posisi untuk pengambilan foto. Ada plakat apresiasi yang akan diberikan dari Pak Ronfeldt kepada Bapak Phillip Kersting. Okay, now it's time for me to invite Ms. Cassandra Ismail and Mr. Phillip Kersting to, you may take your place and start today's workshop.
Thank you.
Is this audible? Yes. All right. Good afternoon, everybody. My name is Phillip Kersting, and I'll be happy to guide you through an introduction to the German Supply Chain Act. Do we have the presentation on?
Yeah.
Yes? Yeah? The German Supply Chain Act is legislation that provides obligations for companies to take responsibilities in their global supply chains in order to avoid human rights and environmental impact. Am I able to see the slide somewhere? Okay, next slide, please. A short introduction to what we do. We're a German law firm with a global outreach. We have a large footprint in Southeast Asia. All in all, we're 420 lawyers in 20 locations, and we mostly support German and continental European businesses around the world. In Southeast Asia, we're present here in Jakarta, in Singapore, Malaysia, Myanmar, Thailand, now opening in Vietnam. And we mainly deal in supply chains. So usually our clients are subsidiaries of German companies that have some role in their global supply chain, or we help German companies source in these countries. Next slide, please. This is a short overview where you can see that outside of Europe, our focus really is Asia. Next slide. Our services in Indonesia, we don't provide the same services in every country. In Indonesia, what we do is legal advice in collaboration with our Indonesian law firm partner, Magdir Ismail and Partners. And we provide incorporation services, company secretary services, so ongoing regulatory and corporate compliance, accounting and HR services. Next slide. What we're going to do today is I'm going to introduce you to the law, its main purposes and functions. Then what does it require from the people affected by it? Monitoring and enforcement being one of those requirements that is most important in this phase right now. And then a guideline on what companies should do. That's a little bit different on whether you're a supplier or if you're a company that has its own supply chains abroad. And at the end of the day, I'm going to give you a little bit of an input what law firms like us can help you with. Next slide. One more. So on the historic background a little bit, this comes from somewhere, right? It was not the idea of someone spontaneously. In 2011, the United Nations introduced what is called guiding principles for businesses and human rights, so that also in the business world, human rights are globally monitored and being taken into account. And I'm not sure if everybody is aware, but there's one incident that perfectly describes why these kinds of laws are and will be necessary in the future. A couple of years back, a factory in Bangladesh producing garments collapsed and buried many of the workers. And in the rubble of that factory were found many, many garments that were destined to end up in German discounter markets. So that was for the layman, that was the first time we could see how much of an impact it has that we are taking advantage of global supply chains. And this led to first the idea and the inception of this law in March last year. And in June last year, it was passed. So that now we are in the phase between the last and the next to last and the last bracket, where the law is in force, but it will only take effect in January next year. That's why we still have plenty of time to discuss what it means to us, what it means to other people in supply chain, what does it mean to me when I purchase semi-finished goods that I then add value to and then only sell to Germany. All those questions become relevant in this context. Next slide, please. Apart from this German initiative, there have been other national initiatives in the past. France, the UK have passed similar laws to put responsibilities on companies in order to make sure that their supply chains don't pose significant risk for human rights. And there's one in the making that will be very significant. I will give you a short overview of what the EU is planning, because later when we talk about the details of the German Supply Chain Act, you will recognize the immense differences between the two. So the EU also will introduce a guideline that basically has the same purpose, but it has higher consequences and a much wider scope. So the EU directive will apply to large enterprises in general, and then to SMEs as well, as far as such SMEs are in risk-prone business fields, for example, the garment industry. And most importantly, foreign businesses that sell their goods in the EU. And that basically means everybody, right? So if you're a global player and the EU is definitely a market for you, this will apply to you. This directive has not yet been passed, right? And also, what this directive will introduce is significant civil liabilities, so that, for example, workers or stakeholders in environmental damages in foreign countries will be able to hold the companies liable in the EU. That's a major development. And at the same time, it will pass, it will capture more of the value chain. So we can basically say that what we're talking about today is the softer version of what is going to come. And this will affect everybody that is affected by what we talk about today, because today we talk about supplying to Germany or working with German supply chains. Since Germany is a part of the EU, this is what's next, right? Next slide. This is just to summarize again the main objectives of the Act. So the number one being protection of human rights, number two being environmental protection, and we do this by creating corporate responsibility for supply chains, and also certainty for businesses in knowing how to handle the requirements. Next slide, please. So one of the main issues and the main driver of this law was the protection of human rights. And as we know, there are horrible images of so-called sweatshops where people work under inhumane conditions, probably not being paid well, some not being paid at all, child labor, things like that. Not to say that that happens everywhere all the time, but it does happen. And it is maybe quite interesting to just, reminding yourself of what that means, human rights abuses in labor. So the Act itself makes direct reference to conventions that were passed by the UN, a total of 11. They are listed in the annex of the law. And these include, for example, the United Nations Convention on Human Rights and the International Labour Organization conventions. And what is a human rights risk, right? It's a situation where a violation of a human right is likely or highly likely. And the bullet point you see down there are not complete. So this is just the main examples of what a human right abuse can be. There are other imaginable topics where human rights abuses can occur, the most prominent being, of course, child labor, forced labor, slavery, occupational health and safety. All those things can count as human rights abuses. Next slide. Environmental protection, I think, is much easier or doesn't have as many levels as human rights. It's not as complex. Of course, there's also international conventions on environmental protection. The Act lists 3. The Minamata Convention on Mercury, the Stockholm one on persistent pollutants, and the Basel Convention on hazardous waste. So again, as we've seen, if we can maybe move one slide back again, the definition of a risk would be basically the same. You just exchange human rights violation against environmental damage, right? Okay, next slide, please. Yeah, there we are. So now we want to look at who is affected by this law at all, right? You will find that this law has a quite, you could say, targeted or narrow scope. It only affects companies with a head office or registered address in Germany, or companies with their principal place of business in Germany. So that already limits the number if you look at it globally. And in a first step, and that's what kicks in January 2023, is the law will apply to companies with employees above 3,000. That's quite significant in size, given that Germany is a country that relies heavily on small and medium-sized enterprises. But those 3,000 are counted not only in Germany, but across the globe. And a little further down in the fine print, so to speak, you can see what exactly is considered an employee. And then in the next step, so to speak, the scope will widen by including companies that have 1,000 employees or more. Still, since we're only talking about Germany, this is not thousands of companies, right? I guess it's a couple of hundred in 2023, and then maybe roughly about 1,000 in 2024. That's why the significance of the guideline that I mentioned earlier is so high, since that one will include any company that sells its goods in the EU. That will basically mean everybody in the world, right? I mean, as long as they sell goods. And there's an indirect effect on direct and indirect suppliers. So direct suppliers are companies that have contracts with German companies to supply them with finished or half-finished goods in the value chain. And indirect suppliers would, in that regard, be someone who supplies, for example, a direct supplier. And as you will see when we go through the details, the Act pretty much, and I think quite well, takes into account the level of control that you or a German company, the level of control that you can exercise throughout the supply chains. Because as a company, I can quite well control my subsidiary abroad, but I only have contractual means of controlling my independent direct supplier, and then I only have an indirect contractual mean of controlling that indirect supplier in how they source their supplies. So, and the law takes account of that. So the level of responsibility will go down with the level of control that the company can exercise. But I will show you that in further detail later. Next slide, please. So the main point is this is about supply chains. And the law is quite broad in its definition of supply chains. So the supply chain is basically everything from the sourcing of raw materials until the delivery at the end customer. So technically, we could speak about conditions in the delivery company, right? Because they supply a service. Usually the delivery, at least the last leg, takes place in the country of destination. So that would be in Germany. Human rights abuses, rather unlikely, but they happen. So even there, a risk assessment will be in order. Next slide, please. So just to maybe re-emphasize what that means for a business that is in Indonesia, right? You may have your own business or work for an Indonesian business. You may work for the subsidiary of a German business here. Both are affected. Both form part of a German business's global supply chain, provided the products or goods that they make play a role in an end product that ends up in Germany. And of course, it's supplied by a company that is situated in Germany, at least significantly. So it could be a German enterprise with their own subsidiary outside. It could be an Indonesian enterprise that just supplies to a German company. Both are affected. And I think especially for Indonesian companies that seek to supply German companies, it is highly valuable to know this upfront, because if that particular German company is too late in implementing this system themselves, it will only trickle down in time to all the suppliers, and being late with this a month or two could kick you out of a bidding procedure, right? Because someone else has already complied. So it pays to be alert. Next slide, please. So the obligations under the Act. We have to look at this a little chronologically, right? We have to imagine a company that has not been affected by any of this before, right? As I said, France, Germany, France, the UK, and some other countries have passed legislation like this. Germany hasn't. In Germany, for now, there has been voluntary measures where the industry vouched to apply risk assessment and so on, and mitigation measures in as far as they see fit. We can understand and also appreciate that no company wants what we call a media shitstorm on the conditions in their supply chains abroad. There's a motivation, an intrinsic motivation to make sure nothing happens. But since we have the law now, obviously, the lawmakers in Germany didn't think that that was enough. So chronologically, of course, if you come from a situation where you have not been regulated on this topic before, the first thing that we have to do is, do I even have a problem, or do I fall under this? Because I might be a German big company, and I might have 3,000 employees, and I may have global supply chains, but I may have zero risk, right? That happens. The first step is a self-assessment. And the law requires these companies to make a diligent self-assessment of their own risks. And this is something that is, how do you call it, judiciable in Germany. So let's say I want to have an easy time. I'm a company, I make my own self-assessment in risks, and what a surprise, I find I don't have risks. So I don't fall under the law. Nothing as easy as that. If later something happens, and a court determines that I have not put enough diligence on assessing my risk, I'm just as liable. So there's no way of finding that I don't have risks, and that's why I don't fall under the scope. That's not how it works. So first I have to diligently assess my situation, my procedures, my supply chain. If I identify a risk, I have to adopt a policy position. So I have to declare publicly as the management that I have risks, that I intend to mitigate them, and so thereby I pledge myself to the cause, right? And then preventive measures have to be implemented. Those include education for employees, not only your own ones, but also those of your suppliers. And it includes systems so that people affected, and that could be a worker working under inhumane conditions, it could be someone who lives close to a production site and fears that there's an environmental impact. There must be systems for those people to report. So that would be your typical ombudsman or whistleblower systems. And this part, if you look at the left side of that slide, that's the situation where you have a risk. Nothing happened yet, right? Nothing happened yet. You have a risk, and only because you have a risk, that's all you have to do. So that's already the obligation that you find yourself in when you just identify a risk. And then comes the right side of the slide where something happens. And the remedial actions that you have to take where something happens, then again follow suit with the mechanism of control that I mentioned earlier. So the more control you have, the more obligation you have to remedy. Meaning, if I'm a German company and there's a human rights abuse in my, let's say in my Indonesian subsidiary, I have to take measures that definitely stop the violation immediately, because I have that power. It's my subsidiary, right? I control the management and I control the shares. If that human rights abuse happens within my direct supplier, I have to take appropriate immediate measures to make sure, in as far as possible, that the violation ceases as fast as possible. There's this, I mean, of course, we lawyers love these differences, right? But the difference in practice is huge. So if I only have to notify a breach to my supplier because something happened and ask him to please stop that immediately, that's an extreme difference to having to basically send my compliance team to Indonesia and research the whole matter and making sure it stops tomorrow. In terms of expense and disruption of procedures, it's a huge difference. So all these measures have to be summarized every year. This provided you have identified a risk. You have to document all the measures that you're taking, the measures that you're taking because you have a risk, and to document your mitigation efforts. Or, of course, you also have to report if there were violations and what you did about it. And there's an annual report that you have to hand in to BAFA. It's a German federal authority that usually deals with exports. This specific authority will also have enforcement measures, and we come to that later. Next slide, please. So risk management and risk analysis, as I just mentioned, the two key words are appropriate and effective. It's basically left to the companies for now what's appropriate and effective. And then there will be best practices that we already know from compliance systems in other areas. But we will only know what's appropriate and effective once the first cases end up in court. Because then German judges will assess whether that particular measure was appropriate and effective. And if it was appropriate and it wasn't effective, it's not good enough, and they're liable. And they will be fined. I will come to the fines later. So, and again, the analysis and the detail of analysis and what's appropriate and effective goes along the level of control that you have. So in your own subsidiaries, you have to be super diligent. You have to look at everything. In your direct suppliers, you have to take every appropriate and effective contractual measure and control that could lead up to training your direct suppliers' employees. And also maybe you have to audit your direct suppliers. Depends on the industry you're in and the level of your risk. But already we're at a little bit of a lower obligation. And then your indirect suppliers, you're only supposed to really do something if you have an actual indication of violations happening or being imminent. So an indirect supplier, since you have less control, there's a party in between, right? Your direct supplier is less of a worry for you than your direct supplier, which is in turn less of a worry for you than your own subsidiary. Again, it's congruent with the level of control you exercise. Next slide, please. The policy statement. I don't think we have to spend too much time on that. The policy statement basically kicks in when you find the risk, right? It's the management, as I just said, stating that there is a risk and explaining what they're going to do about it. But it's important. It must be done, right? Even though it seems petty, it must be done. Because this public declaration has a certain effect, right? What's on your website and in your corporate communication will never go away. Next slide. Now, preventive measures, right, is something that also will come down to the individual situation of every single company. So, depending on the level of your risk and the exposure of those potentially affected, the preventive measures that you have to take have to be aligned with that. And since we don't have precedent in court decisions, we don't know yet what it's going to be. But of course we have areas where we can compare what's effective and appropriate and what makes sense and what doesn't. So all companies affected by this will be in need of making sure that they implement measures that are good enough. And again, as you can see, I will not repeat this all the time because I've done it 3 times. Again, it depends on the level of control you exercise, right? Of course, you can implement more strict measures in your subsidiary than you can contractually with your direct suppliers, and so on and so on. Next slide, please. This is, I mentioned before. So they even make a difference on whether the violation occurs in Germany or abroad. Because they say even if it's a subsidiary, it's still far away, and the level of control or the speed at which I can act against the violation may be different. So again, we have this step-by-step approach on how much control do I exercise, how fast can I act, and that will define how much I must do. Next slide. Compliance systems. Every company hates it, costs a lot of money, and brings you nothing but trouble. Compliance systems are highly important in these contexts, because if nobody has the chance to ever report anything, we can just do away with the whole legislation. Because you will never find out any violation if nobody tells you. Nobody will tell you if they have to expose themselves, so you need effective reporting mechanisms. In bigger companies, and those of you who work in bigger companies, you know that, usually once or twice a year, you have a compliance training where they introduce to you the whistleblower system or the ombudsman, the external one, that you can utilize if you feel that your rights are being violated or if you feel that there's something going on in the company that is not right. Here's the same thing. It just needs to include these obligations as well. And then again, step by step, depending on the level of control that you exercise over the respective company. Next slide, please. Documentation and reporting. It's what I mentioned before. Every year, there's a report being done to the same authority, BAFA, where not only you document that you have measures, you have to document that you have reviewed them. You have to document the results of that review. If you had violations, you have to document what you did about it, what came out of it. And we can clearly see this is also a means for BAFA to gather data and information, right? This is new also to the authority. We have to keep that in mind. So next year is the first time companies will maybe report, or maybe all the companies will only hand in a very short report that says, we looked through our supply chains and we found no risks. I hope not, because then BAFA has to investigate whether they really did their job or whether they just wanted a quick move out. But BAFA, at the end of 2023, at the first time, will be able to compare what did companies do. And those reports not only have to have it into BAFA, they also have to be published, right? And I think they have to, yeah, it's 7 years. They have to be available publicly for 7 years. Why 7 years? Because human rights abuses usually pop up really fast, right? If someone is abused and decides to do something about it, it doesn't take 7 years. Usually it doesn't. Maybe a difference in child abuse cases because they don't come out that quick, but the 7 years are mostly, and I think maybe even too short for environmental impact. Because the environmental impact of industrial production, as some of you may know, doesn't show tomorrow. And most probably not the next year or the year after, but mostly 10 years later. So in order for that to still be documented, for example, by our colleagues from the press, they need to be able to assess those sources, right? They need to be able to look back and let's say German company A that produces chemicals in Indonesia posted in 2005 that everything was fine and they had assessed no risk. And now, 5 years later, we've realized that 5 years before, high amounts of toxic liquids were dumped into the ground. So that's why these information have to stay online and available for everybody for so long. And if you ask me personally, I don't think 7 years is enough, but we're only in the beginning of legislation. Let's see what the guideline will say about that. Next slide. Now, monitoring and enforcement. You will see that now we come closer and closer to the things that people who are present today and also online can do about this. I mean, all of this has been a lot of theory. Next slide, please. So first of all, we look at what can the authority do to you, right? So BAFA has what we in German call special policing authorities for these topics, meaning they can investigate, they can summon people, interview them. Every company falling under the scope of the law has to comply, has to collaborate, give information, and let BAFA do their job. Information access rights, especially in Germany, are quite significant. So if an authority like that knocks on your door in Germany and wants to go to your archive and look at everything, that's a quite significant thing. Because usually it's not just one person, it's a whole bunch of people that carry out documents in boxes, and if the press is present, that's never pleasant. Next. And they can also do something to you. So regular fines reach up to 800,000 euro, quite a significant amount. But as we all know, we have had cases in the past in this country and in other countries where companies were so big and turnovers were so high, they could just price in the maximum fine for what they were doing and just keep on doing what they were doing. So the more modern approach to that is that we, after a certain turnover threshold, we have the possibility to charge them a percentage of their turnover. And 2% of the average annual turnover is quite a lot of money. If those fines are not high enough, we know from past experience that there's no deterrent. We have to keep them high, we have to keep them, well, manageable with the turnover of the companies to make them work at all. And for anything below 400 million turnover, 800,000 is quite a high number. Next slide, please. Now, liability. You may remember at the beginning when I showed you the guideline, I emphasized the fact that under the guideline that's to come, there's civil liability from the guideline. Meaning, the guideline, I mean, I'm not going to dive into European legislation, but a European guideline is immediately effective in every country of the EU and becomes effective law there. So, that guideline, for example, in Germany, will change or amend German civil law immediately. And since it gives civil law litigation opportunities to stakeholders, that means in our initial example of that factory building collapsing in Bangladesh, workers in that factory or their relatives would be able to sue the companies that didn't do their due diligence in a German court or any other European court, because this is a European guideline. And no company will ever be deterred by probable damages that they have to pay, especially in Germany. We don't have exorbitant punitive damages such as in the Anglo-American common law system. We have rational damages. So those are usually not amounts that deter a company. But if you're the manager of a company and the press reports on a poor family from a South or Southeast Asian country that sues you in a German court because you didn't do your due diligence and now their father's dead, I bet you will lose your job. That will not really keep you up there. So the impact of this litigation opportunity is extremely high. And in this law, we don't have that yet. At least not that easy. So this law says there's no direct civil liability from violating the law. Meaning, just because the law was violated, nobody can sue anyone in Germany. They say, however, it can be grounds for general civil liability, which due to the German legal system means, and by the way, sorry for the autocorrect mistakes, we don't have torture laws in Germany. That's supposed to mean tort, okay? So the way it works is paragraph 823 in the German Civil Code opens up civil liability against anyone who breaks the law. And this will be effective law, so any company breaking the law submits itself to civil liability, but they don't say that German courts are competent courts. So usually those things will take place outside of Germany. Not so much of a press exposure. The only thing that may help is that affected stakeholders can use organizations like NGOs or workers' unions to represent their claims. Because usually individuals in the countries that we're talking about don't have the financial means and probably not the educational background to go through with a lawsuit, so they can go through their union or other workers' representations to conduct that lawsuit in general. Next slide. Yeah. What can you do now? I think it becomes quite clear from what we've talked about. Next slide. First of all, make sure whether the law applies to you or not, right? If you're not a German company, it does not directly apply to you. So then what's the question you have to ask yourself? Does it apply to the guy who buys my stuff, right? If it applies to the guy who buys my stuff, is he already in the process of making his own guidelines? Because if he is, I want to know them right now so I can implement, right? Because I want to still keep selling that guy my stuff, right? So that's the first question you ask. And then if you're an Indonesian company doing business with a German company, so you're part of their supply chain, that's really where you focus on. You focus on what is the German company doing under the law. Because the law never affects you directly. It affects you only contractually because you deal with a German company. However, if you're the subsidiary of a German company, it's a different thing because your German shareholder exercises more control over you. And if you're the subsidiary of a German company, I'm sure this is not the first time you hear about this. Because most German companies who know they fall under this, they are already implementing measures, or at least they have this in their education programs. So I think it's most tricky for those of you who are not directly affected, who may be affected by contracting with German companies. And if you are, or maybe some of you, I don't know everybody, some of you are just planning to sell to German companies. So I would think that in a sales discussion with a German company, it will help to just know that this exists and that it will kick in next year and that you signal that you're ready to comply, right? That's a big step forward because those German companies will have to comply. If, as I said, they fall under the scope, right? And then if you fall under the scope, if you're a German company, you establish a risk management system, all the steps we talked about. If you're an Indonesian company and you sell to German companies, then you just become part of their risk management system in as far as they deem fit, right? So there's no way for you to over-fulfill the German requirements. Your German customer will have to tell you what to do. I think it doesn't hurt to question whether it's enough, because you don't want to be caught up in a press echo, but generally you will have to comply with what they deem fit, and then hope that what they deem fit is considered, as we saw before, appropriate and effective under the law. Next slide. Yeah, well, this is my advertising moment. Next slide. We can do all of that. We can assess risks for you, and we can support you in implementing and conducting all the compliance measures that you need. And we do this across borders, so especially here in Southeast Asia, of course. If supply chains go over several countries, it's easy for us to communicate among offices. But this is, I mean, what we can do is not part of this law. Others can do that too. The only thing that's important is that I think at this point, where we're still more than half a year away from implementation, awareness is the most important thing. Being aware of that this will happen, and this is just out of experience, and my real intention here is to say this German legislation is a huge step for Germany, but it's nothing compared to what's coming from the EU. That's really going to hit hard, because the EU includes every company that sells goods in the EU. So any of your customers that are not German will then be affected. And it's going to be a completely different scope. So everybody who has the opportunity to gain experience with this because they're part of a German supply chain now will have a much easier time adjusting to the EU guideline when it comes. And that's already it from me, and I'm really looking forward to your questions. Thank you.
Yes, thank you, Philip, for the very detailed explanation. It surely helped us to understand more about the new law, and also to raise our awareness to these provisions. So we can move on to the next steps, which is the Q&A. Do we have any questions from the attendants?
No? Can I see them?
There is one participant from our Zoom would like to ask. Can you please show?
Hi, Ms. Berterling.
Hi, good afternoon. Sorry, I'm sitting in my home office, and I'm looking for certification. So that's just what you mentioned earlier. My question is, you said the German company will just only send a questionnaire or something to the supplier from time to time. Would the supplier or the company that is within the supply chain, would it be helpful to have like a ISO 37000 certificate for compliance, for anti-bribery, or for 14000 for environmental management system? Or there are also standards for social, like SMETA or whatever, SA 8000. Would that help and put more credibility on the supply chain law?
Thank you, Eva. Maybe if not everybody got this, Eva works for a certification company. Those questions will become very relevant. So, as I said, what's appropriate and effective is not yet certain. Right? And what's appropriate and effective will be subject to the line of business that the respective company is in. If we just stick to the ISO certification that Eva just mentioned, the one against bribery and corruption, that exists, Eva, correct me if I'm wrong, but since a couple of years. And we've seen the first court decisions in Europe where managers back home are being held liable for bribery abroad, where courts have used the fact that an ISO certificate like that was implemented in the country that we're talking about as exculpating and thereby leaving unharmed the management in the headquarters. So they would say, you as management in headquarters implemented an ISO certification in the subsidiary, let's say in Indonesia. Still in that subsidiary, bribery occurred, but what else could you have done? You know, you applied and you fully applied an international standard. You can't just fly down to Indonesia every week and check if everything's fine. Nobody can do that. And then we come back to what I just mentioned before. What you have to do depends on the level of control that you can exercise. So definitely, I think ISO certifications, there will be, again, as we've seen in the past, industry-owned initiatives that provide independent certification. And all of this will, as we say in Germany, crystallize itself in the process, right? So we will have the first court decisions that will then maybe deem or not deem an ISO certification good enough for this business, but that will not mean that it's good enough for the other business, and maybe it's inappropriate for another business. But I mean, at some point, we will need to have an effective system of falling back into impartial certification services, so that we have, something that has no stake in this, right? And ISO, I'm sure, will play a big role. All the certification agencies, you mentioned Sukofindo, all of this will definitely provide services in order to cater to these kinds of laws, definitely.
Thank you, Philip.
Sure.
And we also have one more question from our online participant.
Yes, Pak. You're still on mute, I believe. Sorry, masih di mute.
Good afternoon.
Good afternoon.
Yeah, I want to ask, sir, you talk all the German company should be under the law. How I know the German company is under the law, sir, especially under the law in Germany? Because I want to join with one of Germany companies, sir.
Yeah, I think that's a very good and practical question. So exactly what we mentioned before, how can you know, right? What means do you have as an Indonesian company to research whether that German company has 3,000 or 1,000 employees, and if how many of those employees fall under the definition? That's not your job. Your job, or if you want to be compliant and act decently in the light of this law, the only job you have is to regularly check with your contractual partner if they fall under the law and if that means anything for you. That would be diligent, and I would hope that it would be appreciated by your contractual partner.
Yeah. Thank you, sir.
Thank you, Pak.
Ya, terima kasih, Bu. Thank you.
Any other question, maybe?
Okay.
I have another question. What is your opinion about, there are top 10 most exported commodity from Indonesia to Germany, for example, in this case, CPO. As we know that agriculture sector is one of the sector where we don't see any much development in terms of environmental violation. For example, the palm companies in Kalimantan, for example, some are allegedly killing orangutan, for example. For this kind of sectors, if there is no other supplier, can a German company take them as their contractual partner and then report them as a risk, maybe because it is an allegedly violation, not yet a violation? What do you think?
I think that's one of the sectors where we will see effects of this, because, I mean, CPO can be utilized in a number of ways, but let's just imagine a huge German food manufacturer. What comes to mind? Dr. Oetker? I don't know. They will probably use tons and tons of CPO every year. If they source that from Indonesia, definitely they will have to comply. They're big enough. They are a German company. They have their principal place of business in Germany. And I'm sure any CPO supplier to Dr. Oetker will be part of their hopefully appropriate and effective measures to assess and mitigate those risks. So, and that could be working conditions on fields. It could be clearing conditions when the forest is cleared. Could be how they handle endangered species in that case. Definitely, that would be a perfect example of how this will trickle down into Indonesia.
Okay, thank you, Philip. So, ladies and gentlemen, are there any more questions? So, if there's no more,
May I ask one more? May I ask one more
Sure.
question?
Eva?
Sorry, coming back in from the side. Thank you, Philip. I'm wondering if this supply chain law also complies with the Green Deal. So do you think they will also imply on the products that are coming to Indonesia some kind of carbon border tax? Carbon border adjustment mechanism? Talking about the CBAM?
I think those will be captured in that framework, but this particular law is not designed to do that.
Okay, so
that
that's
would,
different from additional.
Yeah, I mean, it is possible because, as you know, in Germany we have what we call Rechtsfortbildung. So technically it's possible for a German court to find that if that certification is not there, or that if that carbon tax is not paid, that poses a risk in your supply chain that is an environmental risk under the law. That's technically possible, but it's not by definition.
Okay, thank you.
Sure.
Okay, thank you, Ms. Peterling. Is there any question? Or...
Oh, yeah.
Yeah, Pak.
My name is Risma Haji from Develop. What I know that this law will apply on 2023, right?
Yes, as of
Already.
1st January. Yeah.
Yeah. And is this applied for consultancy services also?
Technically, yes.
And is there any one single certifications that we can use for any client that we are dealing with?
Mm-hmm.
So we don't have to be assessed many times. Thank you.
Yeah. I think that also serves well in explaining some details of the law, because as you've also seen with myself, I always speak about goods because it's so easy to imagine, right? But supplies can also be services. I should know, I only provide services. That's very important to understand. An Indonesian consultancy that supplies, let's say, engineering services, surveyors, whatever services, in a supply chain to a German company, just as much falls under this. Of course, in consulting, usually in the consulting work itself, risks are considered extremely low, right? It's hard to abuse human rights in consulting. And it's also hard to impact the environment significantly by consulting. But technically you're correct, and it could be other services, right? Could be transport, logistics, whatever it is, it's a supply. And again, we don't know yet what is considered appropriate and effective in which context, but yeah, there could be at some point a certification that deems suppliers of services in a certain category of risk eligible because they have the certificate. That's definitely possible, but for now we don't know what it is.
Thank you, Pak. So, ladies and gentlemen, are there any more questions? No? So I will give it back to our MC for today, and I thank you all for coming for today's workshop, and we will see you in the next workshop.
Thank you.
Thank you very much. Before we finish today's session, may I ask the closing remarks from Mr. Phillip Kersting or conclusion regarding today's event?
Sure. First of all, thank you all for listening. Thank you for having very constructive questions. I think they serve very well in, in reiterating some of the basic principles and the most important ones. I think this is exciting, but I'm by job excited about laws. For most of you, this will be a hassle in the beginning. I think the questions from the gentleman served well to illustrate that. Having to adjust to new requirements always costs money and definitely nerves. So it will be a huge disruption sometimes to have to comply with this customer and comply with that with the other customer. But things like the EU guideline will serve to harmonize this. I think it's exciting to be talking about this before we start, because there's a lot of things that can happen, a lot of things are likely to happen, but we don't know. And I would urge you to keep yourself updated with what's going on in the implementation of this. Talk to your contractual partners, or inform yourself within your corporate structure if you're a subsidiary, because there are things going on in Germany definitely already. My colleagues in Germany, we have 10 offices there, they can't stop talking about this to everyone all the time, because everybody, or not everybody, but all of those who fall under the scope have to comply. Not all of them have interests or supply chains in Indonesia, but many do. Thank you. Have a great afternoon.
Thank you once again to Mr. Phillip Kersting for sharing your time and precious knowledge, and thank you to Ms. Cassandra for moderating today's event. On behalf of EKONID, I would like to thank everybody who's come here. I hope today's session is going to be useful for all. On that note, let me close today's workshop. I'll see you in the next event. Thank you.